Imagine building a life in a new country. You followed every rule, secured a skilled job that serves the community, and your children are happy, thriving, and integrating into their new home. You pay your taxes, contribute to the economy, and feel like you are part of the fabric of society. Then, a personal life change, a divorce, triggers a bureaucratic chain reaction that culminates in a letter from the Home Office, ordering your young children to leave the country, alone. This isn't a hypothetical scenario, it's a real-life nightmare that befell a family in the UK, and it exposes a critical, often overlooked, aspect of UK immigration law that every migrant family needs to understand. This is a story about how the intricate and rigid lines of immigration policy can clash with the messy, unpredictable realities of human life, with devastating consequences. The story centers on a Brazilian couple, Anna, a senior nurse with the NHS, and Dr. Hugo, a senior lecturer in computer science. They arrived in the UK in 2019, a family of 4 with their 2 sons, on a skilled worker visa route. They did everything by the book, working in essential sectors, raising their children, and contributing to British society. However, a few years after their arrival, their marriage ended in divorce. While they remained on amicable terms, sharing parental responsibilities equally, this personal decision unknowingly set them on a collision course with the UK's complex immigration framework. The bombshell arrived in the form of a letter from the Home Office. It wasn't addressed to the parents, whose legal right to live and work in the UK remained intact. Instead, it was addressed to their children, aged 11 and 8. The letter stated that the children had no right to remain in the UK and should return to Brazil. The letter to the 11-year-old even contained stark warnings about the consequences of staying illegally, including the risk of detention and prosecution. For the parents, the letter was incomprehensible. As the father expressed, it made him feel as if his children were being treated like criminals for a situation entirely outside their control. Their children, who had spent most of their lives in the UK, were now facing deportation to a country whose language they no longer spoke fluently and where they had no immediate family to care for them. To understand how such a seemingly cruel and illogical situation can occur, we must delve into the specific mechanics of the UK's immigration rules. The problem didn't arise from a single mistake, but from a sequence of events interacting with rigid legal requirements, particularly those concerning dependent children and the path to settlement, also known as Indefinite Leave to Remain, ILR. The critical issue began when the parents divorced. Initially, the family was in the UK with the father as the main visa holder and the mother and children as his dependents. After the divorce, the mother, Anna, secured her own skilled worker visa in 2022. This was a logical step for her to remain in the UK independently. However, in the eyes of the Home Office, this action had a significant consequence. It reset her clock for qualifying for indefinite leave to remain. Her 5-year qualifying period for settlement would now start from 2022, not from her original arrival date in 2019. Meanwhile, the father, Hugo, continued on his original visa timeline and was granted indefinite leave to remain in 2024. This is where the trap was sprung. The family, likely believing it was the natural next step, applied for settlement for the children. This application was refused, leading to the devastating letter. The refusal was based on a specific and crucial rule within the UK immigration system regarding the settlement of dependent children. According to the Home Office's Appendix Children Rules, for a child to be granted settlement, their other parent must either be a British citizen, already be settled, or be applying for and being granted settlement at the same time. There are very limited exceptions to this. One is if a single parent can prove they have sole responsibility for the child's upbringing. The Home Office defines sole responsibility as a situation where one parent has effectively abdicated or abandoned their parental duties, and the other parent has sole control over the major decisions in the child's life. In this family's case, the parents were co-parenting amicably with a 50-50th split of responsibilities. This commendable co-parenting meant they could not meet the sole responsibility test. Because the mother's ILR clock had been reset to 2022, she was not eligible for settlement at the same time as the father. Since both parents were alive, involved, and neither had sole responsibility, the children fell into a legal gap. The father was settled, but the mother was not, and the rules require both parents to be settled, or applying simultaneously, unless one has sole responsibility. This created the absurd legal reality where the parents could legally stay, but their children could not. The Home Office's refusal letter justified its decision by stating there were no serious or compelling reasons to grant settlement and that the decision was proportionate to the legitimate aim of maintaining effective immigration control. This legalistic language often feels detached from the human reality of the situation. For the family, the disruption to their children's lives, uprooting them from their school, friends, and the only home they really knew, was anything but proportionate. The eldest son was about to lose a hard-won place at a grammar school, and both children were suffering from anxiety over the uncertainty of their future. This case serves as a stark and cautionary tale for all migrant families in the UK. It highlights that personal life events like separation or divorce must be navigated with extreme care and a full understanding of their immigration consequences. When a couple on a visa-based route separates, it is crucial to inform the Home Office. A dependent partner's visa is contingent on the relationship with the main visa holder. If the relationship ends, the dependent visa is typically curtailed, and the person is given a short period, often 60 days, to either leave the UK or apply for a new visa in their own right. The key lesson from this family's experience is the critical importance of visa dependency and timelines. When the mother switched to her own skilled worker visa, the children's dependency status became complicated. It is unclear from the initial story whether the children were formally moved to become her dependents or remained dependents of the father. Regardless, the mother's new, separate immigration timeline was the root cause of the settlement issue. Had the couple remained together, both would have likely become eligible for ILR around the same time, and the children's application would have been straightforward. For couples facing a similar situation, it is vital to seek specialist immigration advice before making any changes to their visa status. They need to map out a clear strategy for all family members, especially the children. The parent who is on a faster track to settlement might need to remain the lead applicant for the children's visas to ensure a smoother path to ILR for the entire family unit. The rules are rigid, and the Home Office's primary objective is to apply them consistently to maintain immigration control, often with little room for compassion or consideration of the unique emotional and social circumstances of a family. In the end, this story is not just about one family's struggle. It is a powerful illustration of how lives can be upended by the fine print of immigration law. It underscores the immense pressure on migrant families, where personal decisions carry the weight of potential separation and upheaval. It is a call for greater awareness and careful planning, and perhaps a prompt for policymakers to consider the human cost of such inflexible rules, especially when the welfare of children is at stake. The system, in its effort to be orderly, created a profoundly disorderly and painful outcome for two young boys and the parents who are here to legally work and contribute.